killed Arbery have pleaded not guilty to malice and felony murder charges. 60 people have been questioned in the jury selection process since Monday. Michael Moore joins us now to dig deeper on the trial. He is a former U.S. attorney for the Middle District of Georgia. Michael, thank you for being here. So this hasn't been an easy process. Yeah, this hasn't been an easy process, forming this jury. They've had to bring hundreds of people in. It's obviously difficult. This is a relatively small town. So many people have already pretty strong opinions about the case. So what considerations are made in the courtroom when you're attempting to form an impartial jury in a case that so many people know so much about?
This case has a lot of complicating factors too, not the least of which, of course, is COVID. And when you're bringing in this number of people, that slows things down as well. So the judge has to keep things moving. The lawyers need to make informed questions and decisions about which jurors know something about the case, may have some predisposition one way or another. And at the same time, they have to try to do the balancing act of keeping things in perspective. And that is that the case, while it's an important case, it's a homicide case and doesn't need to be seen as something that's going to drag out for months and months at a time, even though probably the jurors who are coming in or who've been summoned in mass may feel that way with 1,000 of their neighbors. So it is a small community. It's a tight-knit community. But at the same time, the lawyers have a job to do on both sides. That's to find, impartial people who have not formed or expressed, at least, decisions about the guilt or innocence of these three men.
So there are some people who have said that they fear potential repercussions for serving as part of this trial, no matter what the verdict ends up being. So how much of that do you take into account when forming a jury?
That's a problem, frankly. Jury service is something that folks, it's their civic obligation. They have the need and the right to do it and an expectation that they will participate in it. But in a case where the tensions have been escalated, that poses a problem oftentimes. I think especially over the last several years, the problem has been that the way that communities react, or certain members of the communities react, would be some type of oftentimes violence or threats toward people they disagree with. That's become the norm, frankly. And we see that even in whether or not we let kids wear a mask to school. We see school board members threatened by uprisings. And so the jurors are not immune from that type of information. So they're sitting here thinking, in this community, if I make a decision one way or the other, am I going to face backlash from the other side? So it's a legitimate threat, and it gives the lawyers one more level, I guess, of the onion to peel back to find out if, in fact, they can select a jury that's fair both to the state and to the defendants in the case. It makes it difficult. It's a complicating factor, not insurmountable, but it's something they've got to deal with, and it will require them to ask deeper questions, and it may require the court at times to intervene as well to make sure that the questions that are posed are not targeted to remove good jurors from the panel, sort of with this false sense that, well, are you terribly concerned? If you tell somebody, are you terribly concerned 100 times, they start wondering, well, maybe I should be concerned.
Right.
Maybe I need to be afraid of my safety. So you really do have to walk do a balancing act. And I think a lot of that will be the responsibility and the function of the trial judge here.
It seems like they're going to attempt to keep the trial in Glenn County. Should there be a consideration of moving it? I mean, I think we're probably already too far down the road for that to happen, but should they have taken that into account?
I think it likely was, obviously, and something that most defendants ask for in a case of any notoriety. But a community has an interest and a right to have the disputes and the criminal actions resolved in that area. That gives the people who live there the confidence in the system. It gives witnesses the convenience. It gives the prosecution a convenience. If we were just going to move things to a neutral place, we'd put all our prosecutors on some island out in the sea and just try trials out there. So the goal, again, is it's not the fact that the story's been in the press or that this area is where the crime happened, but it's rather to find jurors in the community who can set any type of preconceived or pre-expressed ideas aside and be fair and impartial. Doesn't mean you have to be totally that you've got to be a blank slate and have never heard of the case or have never seen some clip on the news. Is that you just can't have formed an opinion that would keep you from listening to the evidence and basing a decision on the evidence and the law that the judge gives you at the conclusion of the trial. So lawyers ask for change of venue all the time. The preference is always to try the case to the extent that you can in the area where the events occurred.
So you mentioned preconceived perceptions that people might have. Obviously, the biggest issue kind of weighing over the top of this entire case is race. And
sure.
Some of the jurors were asked if they think the Confederate flag, for instance, is a racist symbol. And the defense has been arguing that the case has nothing to do with race. How do you think that dynamic is going to play out over the course of the trial?
I think it's likely going to be an issue of whether or not race was involved, or was that a motivator? Is that something that heightened the tensions on the day in question? I mean, to say that this trial has nothing to do with race would be a little bit like saying, Christmas has nothing to do with Christmas trees. I mean, the fact of the matter is that there's evidence in the case that at least one defendant has said that another defendant muttered some racial slur at the time. There's a question now about whether or not the old Confederate flag, the battle flag that's often seen as the sort of the slap against integration that was in place at the time, that flag was on a license plate on one of the defendant's vehicles. And so whether or not that information should come in, whether or not, the defendants would have reacted the same way had this been a young white man or young white woman jogging through their community, would they have loaded up in their pickup trucks with firearms and chased them down? So, it is something that sort of, it's the lens through which the case is likely to be viewed. But in reality, there is evidence in the case that we know about already from public statements and from public reporting that, there will be evidence about racial bias and race feelings in this case. So, it's a tough case for lawyers to move around that. Again, I imagine that jurors are not immune either to seeing protesters and supporters and different groups gather. And so, these things will be in play. It's just one of those things that the lawyers are going to have to move forward with the hand that they have and play the cards that they've been dealt. And in this case, by all appearances, race may very well have been a factor in what happened down in Brunswick.
All right, Michael Moore, a former U.S. attorney, thank you so much for your expertise. We appreciate it. Obviously, a lot of attention is going to be paid to this case as it moves forward.
Glad to be with you. Thank you.
Somebody may be watching this morning inside a home where they're suffering from abuse and violence. The CEO of the National